No, sir.
What?
You are in custody right now. If you leave the courtroom, it's a felony escape.
That's a felony to put me in custody because you have no authority or jurisdiction or standing.
Okay, so you failed to appear for court multiple times in this case.
Your Honor, just for the record, the named defendant is actual property, a registered trade name.
Oh, here we go.
And the case has also been certified as a fraud. I have court certified documents to prove that. That should be on the record. And that's the reason why it was certified to be a fraud, because the plaintiff is a foreign owned private corporation, of which I have no contract with, and neither does the registered trade name. And the registered trade name has been used without authorization and permission, and there's an act of identity theft, and that's probably one of the reasons also why the state has acquiesced that both cases are a fraud. Let me add one more piece of information. I am a foreign sovereign with respect to the privately owned foreign corporation known as the state of Washington.
Yes, on the 303 matter, Mr. Haywood was sentenced to serve 4 days in jail. He failed to report to the jail on June 29, 2023, and we're asking him to be taken into custody to serve that time.
No objection, Your Honor. I actually contacted the jail to make special arrangements to deliver the defendant with the special arrangements to not damage the paper, and the jail refused. So I attempted to deliver the defendant, and objection, the state has no standing as they are representing a privately owned foreign corporation, and the prosecutor is not licensed to practice law in this country.
Okay, so I think it's the 303 that he was convicted and ordered to do jail, and you believe that he didn't comply with jail because there's a docket entry that said defendant complied with jail. Maybe that was an error.
That was probably my attempt to deliver the defendant to the jail, but they refused. And just to clarify, the defendant only exists on paper, just as the plaintiff only exists on paper. The jail refused the paper.
The defendant in this matter attempts to employ the split-person defense, a hallmark of sovereign citizen pseudo-law, by claiming that Mr. Haywood is merely a registered trade name or property. He is attempting to create a legal firewall between his physical body and his legal obligations. In a legitimate court of law, this is a procedural non-starter. Judges view the person standing before them as the subject of the court's jurisdiction, regardless of how they choose to stylize their name in all capital letters or trade filings. When the defendant claims he tried to deliver the paper to the jail instead of himself, he isn't just being difficult, he is demonstrating a fundamental misunderstanding of in personam jurisdiction. The court's authority isn't over a piece of paper, it's over the individual who committed the act. Attempting to walk out during a custody order isn't a rights-based protest, it is a fast track to a felony escape charge.
Here we are today. And the state still hasn't proven standing yet, by the way, as well.
So, Mr. Haywood, it doesn't look like you did the sentence on the 303 matter. And so I am going to quash the warrant. However, I am going to have you serve that time.
Okay, well, I'll deliver the paperwork to the jail. That's fine. I tried to once before, but they refused it. And just to clarify, I'm not the defendant. There is nothing on there, nor is there any testimony from anybody as firsthand witnesses under penalty of perjury that I am the defendant. And I've uploaded plenty of documentation to prove I'm not the actual defendant. That is a registered trade name, matter of public record, and registered with the state. So if you want me to serve some jail time, then we're going to need to change who the defendant is, because I'm not the defendant.
All right. So can you upload a new commitment?
Yes, Your Honor.
And the reason they couldn't put my name on there as a defendant is because I'm a foreign sovereign with respect to the corporate entity known as the state of Washington, of which I have no contract with.
Well, you had your day in court on the 303 matter. You had a trial. You represented yourself or the defendant, whichever way you want to say it, but you represented the defendant yourself, and you were convicted, and you were ordered to serve 4 days in jail. You didn't do that. And so
The defendant was ordered to serve 4 days in jail, and I attempted to deliver the defendant to the jail, but the jail refused.
okay, well, I'm going to make sure that they don't, because I've done a new commitment for you today. so that they won't refuse for the defendant to serve that time. You're going to serve those 4 days, and then you'll be released, and nothing more will happen on that 303 case. You'll be done. And then this case will be heard August 24th at 10:30 in the morning. If you change your mind about representing yourself, then you can ask for help if you want it. If you don't want help, we don't have to have it. So we'll see you in August. I'm going to have you take a seat right over there.
I won't be here for the defendant August 24th. Would you like me to deliver the defendant to the jail?
I would like you to sit over there
Is there any standing
with the
or
defendant.
jurisdiction chosen, proven here yet?
Please go take a seat.
Okay, so let the record reflect no jurisdiction has been proven, and neither has the identity of the defendant definitively been established.
Okay, please go take a seat. Sonia Sesko, customer 231024002. Mr. Haywood, sit down.
Am I obligated to follow these rules?
You are going to sit down right now.
Do you have any jurisdiction? I don't believe you have any jurisdiction that's been proven yet.
Please sit.
Are you threatening me with violence?
I'm asking you to sit down.
You only have authority over the defendant. You have no authority.
What are you doing?
Mr. Haywood?
You're escaping?
I got things to do.
No, sir.
What?
You are in custody right now. If you leave the courtroom, it's a felony escape.
That's a felony to put me in custody because you have no authority or jurisdiction or standing. You got some proof of that?
Okay, well, we are all being recorded, so if you leave this courtroom, it'll be a felony escape charge. Your choice.
Okay, well then, I guess in the best interest of peace, in regards to your violence, I will go ahead and relax for a minute, but let's get with it. I got things to do. Got it?
What was that just thrown?
Car keys.
Do you know that person?
Yeah, they're my voice.
Okay. All right. So thank you. Mr. Haywood has been very disruptive. He tried to leave the courtroom once he was placed in custody. So just FYI, be careful with him.
So, give me a break. Can I just see just need to see it, thank you. Can I see who's being put into custody, please? I just need to see the name. I just need to see the name of the person. Okay, that's not me, that's the problem here.
Our Sanborn's matter, we're here today on.
That's not me.
Who's
The name is saying it, but that's my registered trade name. I got all that documentation right here.
Okay, good. We're
You want
gonna take care of
it?
it.
Okay. Yeah. Well, this is the defendant technically.
If you want that, I can go with you, put everything private.
Hold on 1 second. Well, that's taken care of.
We can figure it out and get the right name.
Did she file a notice of appearance?
I will make sure that she does, Your Honor.
Okay. Yeah, sorry, I haven't had enough coffee yet today. So yeah, no, you've got Ms. Bradshaw, so that's fine. You don't need to do those forms. But she does need to file a notice.
To the casual observer, the defendant's arguments might sound like a complex legal cheat code, but to the bench, they are a tired script of debunked theories. Let's be clear, the foreign sovereign argument, claiming the state of Washington is a private corporation, is a legal fantasy. While governments do have corporate aspects for administrative purposes, they possess sovereign immunity and the inherent police power to enforce criminal statutes. When this defendant challenges the prosecutor's standing or the judge's jurisdiction, he is demanding a proof that has already been established by the very fact that he is standing on the court's floor. Jurisdiction is not a contract you opt into, it is the geographic and subject matter authority of the court. By refusing to sit down and attempting to leave, the defendant transitioned from a simple compliance hearing to the brink of a life-altering felony. The trade name defense is particularly dangerous because it lures defendants into a false sense of security. They believe that by filing a UCC-1 financing statement or a notice of appearance for a fictitious entity, they can shield their physical person from the consequences of a criminal conviction. As we see in this transcript, the judge remained remarkably patient, but the law is not a game of gotcha. The moment she issued the new commitment, the legal fiction was over. The lesson here is simple: the law operates on reality, not semantics. You cannot relax for a minute. When you are in custody, you are either compliant or you are a fugitive. This defendant's boys in the gallery might have cheered, but they won't be the ones sitting in a cell for those 4 days. In the eyes of the law, there is no paper defendant, there is only the person who failed to report to jail. What did you think of the judge's patience? Was she too soft, or did she handle a volatile situation with the right amount of pressure? Sound off in the comments, we're reading every single one.